Good afternoon, everyone. Thank you so much for joining us. My name is Daryan Jones. I'm the Caregiver Education and Digital Specialist at Care Partners. Today, we're going to have a very special guest, Charioty James, she's an attorney, an elder law attorney, and she's going to be telling us about some really important documents and things, estate planning and probate as well. So I'm just going to invite her on and we'll go ahead and get started. Hi, Charioty. How are you doing today?
Good. Thank you so much, Daryan.
Can you just tell us a little bit about yourself and what we're going to be talking about today?
Absolutely. Well, my name is Charioty James, and I'm the managing partner of James and Parlange Law. We're a law firm located in Kingwood, and I've been practicing law about 18 years, Daryan, so I'm dating myself a little bit. But I started out my practice in corporate defense, but I have been doing estate planning and probate for the last 11, 12 years. And so over the course of the years, we've seen a lot in our practice, especially doing the probate side of things, which is what happens when you pass away. We were able to get a lot of information that is very helpful for people on the estate planning side. So today I just wanted to talk a little bit about estate planning and the documents that are important. And there are several things in addition to those documents that don't cost you a dime that you need to do that are just as important as those documents. So I'm going to go over those things as well, Daryan.
And I'm really looking forward to it because I know you're going to cover some really, really important and helpful things today. And I guess with that, we can just go ahead and get started.
Okay, that sounds good. Well, Daryan, there are 4 documents that are really important in estate planning. And the first document, everybody kind of knows what it is. It's the will. And your will has no force or effect while you're living, but when you pass away, the will is used to distribute your property according to your wishes. And that's the document that would be used in probate. And depending on your life circumstances, your will can do several things for you. For instance, if you have minor children, you can appoint guardians for those minor children in your will. You can set up a testamentary trust in the will for the sake of your children or your grandchildren. And you can make the ages on those trusts be 18, 25, whatever age that you choose. So the will is very important. And really, probate law in the state of Texas is devised to be efficient and economic. And a lot of that is dependent upon good estate planning. If you do not have a will, the probate process is typically much more difficult and much more expensive. And I have done whole conferences on just the probate aspect of administrations when people do not have wills. So a will is always a good idea, not only to make sure that your assets are passing according to your wishes, but also to ensure that you have a very efficient and economic form of probate that you can use. And so that's the first document. The second and third documents are power of attorneys. So we'll take the medical power of attorney first. Now, these power of attorneys are used while you're still living, but you've become incapacitated for some reason. And so the medical power of attorney allows somebody to make medical decisions for you and to access your medical records if you cannot, you're not competent to do that on your own. And typically we have a primary agent and a secondary agent that's able to make those decisions for you. So very important document. The third document is the statutory durable power of attorney. Now, a lot of lay people will call that the financial power of attorney because it typically handles everything else except the medical side of things. You have a separate medical power of attorney because the HIPAA laws require you to have that separate medical power of attorney. So that statutory durable power of attorney will give someone the ability to be able to manage your investments or to sell real property if they need to, essentially just to do any administrative work that would need to be done to take care of you. And a lot of times people really labor over who their executor is going to be in their will. And I tell people that should be a relatively short-lived job, whereas the agent on your statutory durable power of attorney is actually something you should labor over. That's a very important position. You have no idea, no way of knowing how long you may be incapacitated or how long you may live in an incapacitated state. And so this could be a job that's ongoing for a long period of time. And so you want to make sure that you appoint a person as your agent that is not only trustworthy, but is a good manager of finances, because you want your money to last you, to take care of you for the rest of your life. And statutory durable power of attorneys can be very specific, very involved. For instance, you can make elections to allow your agent to be able to gift property away in certain circumstances. For instance, if there's a tax benefit, you can allow your agent the ability to be able to change beneficiary designations or pay on death designations that you've set. So a lot of thought goes into not only the drafting of that statutory durable power of attorney, but the execution of that power of attorney. And so my recommendation to people always is make sure that when you sit down with your attorney to sign that statutory durable power of attorney, that you have that attorney explain all of the choices and give some real life examples of how those choices can impact you or your agent when the time comes, so that you know that you're executing that document properly. And the fourth document is the directive to physicians. And a lot of times people will kind of confuse that with the DNR that you fill out at the hospital. But what the directive to physicians does is, if you are on life support and there's no viable means that you're going to come back, it allows your wishes to be known about being unplugged. Now, a lot of times people will say, well, doesn't my medical power of attorney have the authority to be able to sign to have life support removed? And yes, they do. They do have that authority. But where the directive is helpful is, number one, a lot of times people will be in disagreement about whether or not to unplug. And so there could be a situation where the family is fighting, and that directive is just a very helpful tool to be able to step in and say, you know what, this is what his or her wishes were, and we're going to abide by that. So the directive is very helpful in a situation where you have some disagreement going, but also it kind of alleviates some of the emotional trauma that would come from your medical power of attorney having to sign to remove life support. So very helpful, good document. I definitely recommend having a directive. Now, those are the documents that a good estate planning attorney would typically prepare for you. But now I'm going to go into some things that typically nobody tells you about. They don't cost you anything, but they're just as important as any documents that an attorney can prepare for you. And number one is beneficiary designations. So when you pass away, everything that you own does not flow through your estate and through probate. And so things that have a beneficiary designation do not flow under your will. And so you want to make sure that you update all of your beneficiary designations. And again, I recommend putting a primary and a secondary. And things that require beneficiary designations are life insurance policies, investment accounts, things of that nature. That's what you're going to see your beneficiary designations on. And so make sure that when you fill out those beneficiary designations, that you actually ask whatever third party that is that you're working with, make sure that you touch base with them to make sure that you fill them out properly. Over the years in doing probates, I have seen people who had every intention of splitting things equally among their children, for instance, make a mistake in completing the paperwork. And instead of putting their children on the same tier, they actually made them primary, secondary, and tertiary. So you just want to make sure that you're understanding that third party's paperwork, and that you're filling those out appropriately so that it goes according to your wishes. And the next thing is, I recommend that you put a pay on death on your accounts. at the bank. This is checking accounts, savings accounts. And again, this is free to do. You just go into the bank and you tell them that you want to put a pay on death on your accounts. Now, operates like a beneficiary designation. It allows you to say who you want to have that money, and whenever you pass away, they bring a death certificate. Typically, they bring a death certificate into the bank, and the bank cuts them a check just like they are a beneficiary. Okay, so wonderful tool to use at the bank. And many times when people take advantage of the opportunity to be able to make beneficiary designations or pay on death designations, they are able to, or their family is able to choose an alternative to a full probate, which is an even cheaper and more efficient probate process. For instance, if you only own a home when you pass away and everything else has passed according to your beneficiary designations or your pay on death designations, you could possibly have the will probated as a muniment of title. And it is a quicker, more efficient process that doesn't require any administration. So just good to take advantage of. And my recommendation also on bank accounts, a pay on death is safe to do because the person has no ownership of the account until you pass away. And never add anybody to your bank account that's not a spouse, because you don't want to take on their liability. So I want to make sure that I make the distinction from adding someone to your account as opposed to just listing them as a pay on death. Now, the next thing that's extremely helpful, and this doesn't seem like such an important thing right now, but I can tell you every family that finds this when their loved one passes away, it's huge, a spreadsheet. Make a spreadsheet or a list. You can use Microsoft Excel or whatever works for you, a list of every single account that you have and every life insurance policy you have, and passwords. So important. So many times over the years, I've had people come in and say, I have no idea what they had. Can you do a full search and find out every investment they had and where they had their accounts? And a lot of times what we have to say is wait on the mail to come in and go and look through boxes or places you think they would have kept important documents. And there's a lot of digging that has to happen. If you have a spreadsheet and you keep all of your online passwords, every life insurance policies. I mean, if you think about life insurance policies, typically they only renew once a year. And so you can imagine the family may not know for a length of time that you even had that life insurance policy. And I usually recommend something like Microsoft Excel because it's a little bit of work on the front end, but it's very easy to update and maintain after that. And so, and just in recent years, Facebook passwords and email passwords have become very important. You want your family to be able to shut down all of your accounts if something happens to you. And so it is that spreadsheet is just as critical as anything else that you can leave or do for your family. Very important. Documents that are important when someone passes away, things that you will need to gather. The documents that we talked about at the beginning, the will, that's going to be an important document that needs to go into the attorney. And also deeds to real property, titles to motor vehicles. Those are all documents that you'll want to bring in. Of course, any copies of beneficiary designations and pay on death. That way the attorney, when the time comes to probate the will, can sit down and get a good look at exactly what assets are in the estate, what debts are in the estate, and what housekeeping or administrative work needs to be done. And hopefully that attorney will be able to fit you into the most economical form of probate that you can possibly do. So one little side note about those accounts. Back in the old days, I say the old days before internet and before live streams, People would read the newspapers, and thieves would actually read the obituaries. They would find out when funerals were going to happen, and they would go in and they would rob the house during the funeral because they knew everybody would be at the funeral. And what we see nowadays is identity thieves will actually go in and they will hack accounts of people that have passed away. So they're looking through obituaries and they're looking to hack accounts. And so you want to make sure that your family has everything necessary to be able to shut down any email accounts and any Facebook accounts or anything that could possibly be used to be able to hack into your accounts. You want to make sure that those are shut down. So, sorry, I don't know what happened to my live stream. Hopefully you still see me. So does anybody have any questions? I haven't seen any questions or comments. Daryan, have you seen any come through?
Let me take a look. I haven't seen any just yet. So anyone who's out there watching, if you guys have some questions, we'd love to hear from you guys. So just feel free to type those in the comments below. But I had a question. So I was wondering, when should someone start planning or getting these documents together?
Good question, Daryan. A lot of times people don't think about it until they get, into their later years. But the reality of the situation is it's extremely important, especially if you have children, minor children, that you do your estate planning. One of the most difficult and expensive forms of probate in Texas is when someone passes away without a will and they have minor children. Typically, the courts require that you do a dependent administration, which could take a very long time and requires a lot of court oversight. And so my recommendation is, if you own property, at all, whether you have children or not, if you own property, it's good to go ahead and get your estate planning done. And even more pressing from a guardianship standpoint, once you have children, you want to be able to make sure that you've appointed guardians for those children in your will. So everybody needs a will that has property.
Oh, that's some great advice. Thank you so much. And you talked a bit about it, but do you have any advice or pointers or things to think about before someone puts someone on one of these documents to have control of what happens to them?
Absolutely. Like I said, on the statutory durable power of attorney, that agent is really a very important role. And so considerations that I usually kind of tick off with people, how are they handling their own finances? That's a really good indicator of how they're going to handle your finances. So you want to make sure that it's not only someone that you trust, but somebody that's going to do a good job, and they're going to be able to allow your money to last you, to take care of you for the rest of your life. So you're thinking about those considerations. And I don't typically recommend co-agents. A lot of times people will say, well, I have 2 kids and I hate to pick one over the other. And the reality of the situation is the one that you're not picking has won the lottery because they don't have to worry about it. And so it's not like that person is losing out on anything. But a lot of thought should go into picking that person and who's going to make those decisions for you. A lot of times on the medical power of attorney, people will choose the person that has some medical background or medical knowledge, which tends to be helpful.
Okay, that's some really great advice. And then we'll leave it with this. You talked some about probate. So a lot of people talk about avoiding probate. Is that something everyone wants to do, or is it okay to have probate sometimes?
Well, typically most people in Texas have to have some form of probate. It's kind of unusual when someone passes away and they don't have anything. You see that sometimes in very elderly people, maybe that have already gone into a nursing home or some sort of nursing care. But most people need a probate in Texas. But here's the good news. There's a lot of states that have bad probate laws, and you have to get into complex trust to be able to try to avoid probate in those states. Texas is not one of those states. You typically do not need a trust to avoid probate because The probate process is designed to be easy and efficient. If you can avoid probate, great, that's fantastic. But if you have to have probate, which 99.9% of people do, it is not the end of the world. A good attorney will find the most efficient, economical way to walk you through probate. And the process is designed to be, I'll use the term user-friendly. It really is designed to be easy for the executor to do. And there's lots of helpful resources too. Not only should the attorney be very helpful in walking the executor through the process of what their job is, as opposed to what the attorney's doing, but also the courts have lots of resources on their websites to help administrators and executors through that process. So avoidance of probate is great, or alternatives to probate, like probating the will as a medium of title just to transfer property, is great. But if you have to have it, it's not the end of the world in Texas.
Thank you so much. And then, do you have any final tips or tricks or things people should think about when they're thinking about estate planning?
Yes, my recommendation is come in and talk to a good lawyer. We have free estate planning consults, and I love to sit down and chat with you and see exactly what you have, what assets you have, what concerns you have, and how you want to leave your property. It's always safe to talk to a professional, and just to make sure that you're doing it correctly and you're doing it in the right way, so that things end up the way that you want them to, and it's the most economic thing for your family. And so anytime you can visit www.jparlaw.com, or our phone number is 281-358-8836. And I'm happy to sit down and chat with you and talk to you about your estate planning needs.
Yeah, I got that contact information up on the screen there. So if you guys do have more questions or you want to reach out to Charity, you can reach her there. We really, really appreciate you taking the time to answer these really great questions and cover this important information with us.
Thank you so much, Daryan.
Thank you. So we're going to say goodbye for now, but thank you so much.
Thank you. Bye-bye.
And thank you guys so much for watching today and joining. And we hope you found some value in this and you had some of your questions answered. We'll be back with some more resources and information, hot topics very soon. So thank you guys so much. Be sure to check the Care Partners website for updates on our programming and events. We are continuing to suspend them until May 31st. So at that time, we'll reevaluate and let you guys know what we're doing. Until then, we will see you guys soon. Have a great day.